Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. You might have heard about or watched a 1993 movie starring Harrison Ford. It was called The Fugitive. It was based on a 1960s vintage television series of the same name. Both were loosely based on the true crime case brought against Dr. Sam Sheppard. What had happened was that in 1954, Dr. Sheppard was arrested and indicted for the unaliving of his pregnant wife. At all times, he proclaimed his innocence. There was massive pretrial publicity that attended the case. It was negative, and it was against him. The matter ultimately reached the United States Supreme Court. Dr. Sheppard felt that the quote-unquote circus environment that attended the trial violated his due process privileges as protected by the 14th Amendment to the United States Constitution. It says that when the government is seeking to take a person's life, liberty, or property, that he's entitled to due process of law. He argued that his Sixth Amendment privileges for a fair trial was impossible. The Supreme Court agreed. The Supreme Court of the United States vacated the jury conviction and held that, number one, the massive, pervasive, and prejudicial publicity attending the petitioners, that was Dr. Sheppard's prosecution, prevented him from receiving a fair trial consistent with the Due Process Clause of the 14th Amendment. And you can find that discussion at page 384 U.S. 349 through 363. Additionally, although freedom of discussion should be given the widest range compatible with the fair and orderly administration of justice, it must not be allowed to divert a trial from its purpose and adjudicating controversies according to legal procedures based on evidence received only in open court. You can read that at the decision. The citation is 384 U.S. 350 through 351. That means if you go to the U.S. Reporter, 384 U.S., go to pages 350 and 351, and you'll be able to read that finding by the U.S. Supreme Court. Dr. Sheppard was granted retrial, and he was acquitted during his retrial. Unfortunately, he only had 4 years of freedom to live. He died in 1970, 4 years after his retrial on these charges. Now, turning to Idaho versus Kohberger, there, I believe, can be very little argument that this too is a notorious case that has received massive pretrial publicity almost from the start. In fact, in the granted motion for change of venue, in the order granting defendants' motion to change venue, then presiding jurist, Judge John Judge, addressed the massive publicity that has attended this case from day one. This is an extremely tragic case. There's been massive pretrial publicity, and what Judge said, and you can find this in the order granting defendants' motion to change venue. It was filed September 6th, 2024, changing the venue out of Latah County, which had jurisdiction over the crimes, and where this case should be proceeding but is not because of judge's granting of Mr. Kohberger's motion for change of venue, where he too argued that his constitutional rights to a fair trial had been impeded by massive pretrial publicity. And in fact, within this order, the court addressed the fact that very early on in the proceedings, the parties stipulated to a non-dissemination order, which was amended. It's been in place ever since. And what judge found the purpose for this non-dissemination order is to protect Mr. Kohberger's rights to a fair trial. There has been a barrage of negative publicity over the past several days. In the order granting change of venue, the experts who testified at the hearing in August of 2024 leading to the order being entered talked about the impact of negative publicity, not just in Latah County, but in Ada County as well. Now, bear in mind that some of these findings that you see in this order were based on studies that occurred a year ago. One wonders what any study that an expert on behalf of Mr. Kohberger in Ada County would find after the recent airing of such things as the entire video purported to be of suspect vehicle 1, which has never been released in this case, photographs and searches from the 8458 phone, and other information that was negative. So we await to see what, if anything, the defense is going to bring before Judge Hippler, and what, if anything, is going to arise out of this. Bear in mind that this recent negative publicity is coming just 80 days before voir dire, which is jury selection, and at a time when it is not known as of yet when the jury questionnaires are going out, because that information is under seal. If you have any comments, any thoughts, any feedback, please leave it here. My name's Kathy. Thank you for joining us today.